Hello, everyone. It's very nice to see you all. Good afternoon, Your Honor, Emily and Shaunna. It's nice to see you on a summer afternoon. It's super hot outside, but it's nice to be here to chat with you because I'm going to be chatting with you about a very important subject, and that is Gladue and the rights of Indigenous people, especially in the criminal justice system. Before we get into the subject, though, I just wanted to briefly introduce the guests. I will introduce His Honor Justice Brock Jones. He needs no introduction. Anyone who practices in Ontario, especially in Toronto, knows His Honor Justice Brock Jones sits in the Ontario Court of Justice at 10 Armory in Toronto. He was a former Crown, and he, as a Crown, was focusing a lot on youth matters, and he still does focus a lot on these issues as well as Indigenous issues. And he had some recent important decisions, including Nanabish, on this issue. I also have two guests who really are the perfect guests to talk about anything Indigenous related. And I have Emily Hill and Shaunna Kelly. I'll let you introduce yourselves with your lovely voices. So, Emily, if you can start, please.
Sure. Yeah, thanks for having us. My name is Emily Hill. I am the senior staff lawyer at Aboriginal Legal Services. And in that role, I'm also the manager of the court workers, as well as our criminal and child protection programs.
Thank you. Shaunna.
Perfect, thank you. And yes, thank you for the invite today. So I'm a criminal defense lawyer. I'm Anna Schnaube. I'm a member of the Mississauga First Nation. I'm also Canadian Irish. And I work here in Toronto, but I was raised in Sudbury. And I'm also the Indigenous director, currently the Indigenous director to the Criminal Lawyers Association. I've also sat on various committees and groups regarding the Gladue Court. I've been the Gladue Court rep to the Criminal Lawyers Association since about 2015. And I've done consultation across the province in terms of setting up Gladue courts. And I always like to focus on providing the education to individuals for those who both work in a supportive role in the Gladue courts or are working as litigators in the Gladue courts. So again, thank you for asking me to join today.
Well, it's very nice to see you all. And honestly, this is really a perfect panel to talk about everything Gladue. And so let's start with the basic question. And what is Gladue Court? I mean, and why does it exist? I don't know who wants to start and take the lead, but let's start with this basic question.
So I could start with why it exists and then, or sorry, what is, maybe I'll start with why it exists and then I can pass it on
Mhm.
to what it is to somebody else. So why it exists, I mean, why it exists stems back from, the time of colonialism. Indigenous people were here well before the Europeans arrived. And I mean, I think everyone basically knows the history, but through the Indian Act and the imposition of systemic discrimination or policies that were focused on systemic discrimination and colonialism and the negative impact that those programs have had on Indigenous people, which is all a really quick way of me summarizing the systemic impact on Indigenous people that has then resulted in the overrepresentation of Indigenous people in the criminal legal system. And so I'll turn to somebody else for what Gladue Court is, but the reason that we have it is that for the overrepresentation. One of the guiding decisions that kind of led us down this path was the Supreme Court decision in 1999 of Gladue. And one of the reasons why there's been so much momentum over the last 26 years, sorry, I had to do the math, was because there continues to be the overrepresentation of Indigenous people. There continues to be the rise in of Indigenous people before the courts and issues that are left unresolved. And so decisions like IPLE have really kind of encouraged the continuance of these courtrooms. And so over the years, the Gladue Court has evolved and changed to face those needs. But before we get into that, I'll turn it over to somebody else in terms of what is Gladue Court.
I'll just jump in as well, just to maybe just put some numbers. I mean, to what Shaunna was saying about the ongoing need, I guess, for Gladue Court. When the decision came out in 1999, the court noted that 12% of inmates in the federal system were Indigenous. And the most recent numbers that I've seen, 2022, 2023, say that for Indigenous women, they account for 49% of female admissions, and Indigenous men is 32%. So, obviously that the initiative to address mass incarceration and the vast overrepresentation of Indigenous people in Canadian prisons and jails, proportionate to their representation in the Canadian community as a whole, is just as pressing, more pressing now than it would be. Than it was in 1999. And I guess the other thing that I always think is important to sort of pull out of Gladue in terms of its purpose or its need is the court uses the word estrangement, talking, what Shaunna mentioned about the impacts and the ongoing impacts of colonialism, and the fact that, before colonialism, Indigenous communities and nations had perfectly functional justice systems and took care of justice matters in ways that worked for them. And so then dealing with a colonial legal system imposed on a community along with all sorts of other racist practices has led to this disconnect and estrangement. And so I think Gladue is one mechanism to try to address that estrangement and that disconnect between the colonial legal system and Indigenous people's sense of justice and justice systems.
If I can just add something, I
Yes.
can't possibly do any better than those two answers. But on a purely technical basis, one of the reasons these courts exist is because Parliament has included in the criminal code a section specifically designed to look at the unique circumstances of our Indigenous peoples and how that should be incorporated right into the criminal justice process more broadly. So we have to give it effect somehow when these courts have been designed with those principles in mind, and to take an approach more based on restorative justice and an attempt to consider everything that Emily and Shaunna just talked about, and hopefully through a more sensitive mechanism. In a courtroom, honestly, if you have the chance to come and see one, especially the one at 10 Armory, it just feels different and looks different, and the experience is different, more attuned to the cultural needs and backgrounds of our Indigenous peoples. Hopefully, a little bit better every day, achieving results that are more attuned to a restorative justice approach, which is what Parliament has instructed us to do. And the Supreme Court has, of course, interpreted that section in a variety of very important decisions, including Gladue itself.
And on that point, Your Honor, what's very important also to note is that the criminal code actually mentions Gladue principles at several stages in the criminal justice system process. It's at the sentencing, at the bail hearing. So it's something that courts should be mindful of at every stage of a criminal proceeding. So that's really an important point to remember, that it is also legislated and it's present in the code. But okay, so this is what Gladue Court is about in general, but what's different from a defense perspective? And that's more for both of you, Emily and Shaunna.
So I guess I'll start again, and then I'll pass it over to Emily. So the one thing I will just mention about the Gladue Court is that we're referring it to here as a Gladue Court. We in Toronto call it the Gladue Court, but we are also kind of, I think I practice in Toronto. And so my familiarity is mainly in Toronto, although I have some familiarity outside of that jurisdiction. But when we're talking about the Gladue Court, we are talking about some principles that are, can be referred to in the Indigenous Persons Court that they have in other jurisdictions. We will talk about that a little bit later, I think, about the differences across the province. But I just wanted to point that out. The difference from a defense perspective in terms of Gladue Court touches a little bit on what I was referring to earlier, and that is like the changes that have happened in Gladue Court. When Gladue Court was first designed and opened in Old City Hall in, I think, 2001, I wasn't practicing yet, but these are stories I've heard from other people. It was new and people were trying things out, and it was a welcomed addition to the Old City Hall. But of course, things have changed significantly since then. I don't know what the policies were at that time, but I can say that even just from practicing in the court, I was called in 2009, started more or less working more in Gladue Court by 2011, 2012. And I can tell you even since then, in the last 12 years or so, the the tone has changed within Gladue Court. It used to be a guilty plea court. I think it is still in some jurisdictions across the province, so I don't want to speak for everybody, but in Toronto, we now address bail, we address remands, we address bail variations, we address basically anything except for trials in Toronto. And there's a lot of benefit from that. It's not just the atmosphere, although that's a huge contributing factor for why it's a different court. And but one of the reasons why we're able to do that is because we're not directing someone towards a guilty plea. We're not furthering by, just by default, that increase on the criminal records, or increasing the amount of people who are placed on probation, or increasing the amount of people that are, caught up in the system on this revolving door of administrative charges. By opening up our Gladue Court to all sorts of processes, we take away that pressure from people to plead guilty. And I think that's a significant change that's happened in our Gladue Court that has been for the better, because we really don't need to focus on, whether or not this person is going to plead guilty and what's the best outcome. We can focus on a whole series of different options for them. So I think that's the main difference. But of course, there's all the other little tiny differences, and that is, just the atmosphere, the fact that it's less litigious, the fact that we don't stand up, to address the court. We sit in a circle. We are working collaboratively on most days, or at least that's our aim, to do that. And so there's a bunch of little differences that really make a significant change in the lives of those who come in through the court.
Thank you, Shaunna. Emily.
I guess, echo. I mean, I think Shaunna's point is well made, that what it looks like in downtown Toronto may not be, what Gladue Court looks like across the country, and that is as it should be. There are again different legal traditions and in different parts of the country, and different Indigenous communities have stepped up in different ways to to participate in these processes. So I think that is important. I think thinking, my main experience though is with Toronto, and I think one difference is that you would hope in Gladue Court that all the participants, judges, crowns, duty counsel, defense lawyers, that all have insight into the ongoing impacts of colonial history, and that allows for a more nuanced discussion of those factors in relation to a client's experience at whatever stage of the court process it's at. So I think that's something that we would hope would be a difference, and an increased willingness to use alternatives, to think outside the box in terms of the processes that are available, obviously within the constraints of the criminal code and the requirements of jurisprudence, but to sort of have more opportunity to, as Shaunna said, work collaboratively and explore other ideas. And then I think practically there's just some access to some things. Shaunna mentioned the sort of different layout of the court. Aboriginal Legal Services has court workers in Toronto that are based on the same floor as the Gladue Court. So having access to Indigenous court workers to help with system navigation and diversions and other services, as well as things like smudge, access to an eagle feather, some pieces of sort of cultural connection that can be more available there than they would be in other courtrooms.
So thank you, Emily. I mean, you've touched upon, you started to touch upon the next question that I was going to ask you, and it is actually about what is Aboriginal Legal Services, and what is its role, and what services does it offer. So I know you started talking a bit about that in your previous answer, but if you can maybe elaborate a little bit more for people who are not familiar with your services.
Sure. So I mentioned our court worker program, and that's actually one of Aboriginal Legal Services' oldest programs. And there are court workers run by other Indigenous agencies and other courts in Ontario and across the country. But Aboriginal Legal Services offers court workers in both the youth and adult Gladue courts at 10 Armory, as well as at the Family Court at 311 Jarvis. And as I said, that their role is to assist Indigenous people who are navigating, what can be a very frightening and alien, intimidating legal system. Also to provide referrals for folks within the community here in Toronto. They're really knowledgeable about services that are available that may be of assistance. They will prepare support plans for bail applications and also facilitate the diversion program, which is another service that Aboriginal Legal Services runs. There's a community counsel program, which is also a very long-running program at Aboriginal Legal Services, which is a criminal diversion program, again, for adult and youth in Toronto. And that in the right cases that are approved for diversion by community counsel and by the Crown, takes cases right out of the justice system and brings them before members of the Indigenous community here in Toronto. Those members of the community council, volunteers, all from the community, sit with the person who was previously before the criminal courts and talk with them about what, sort of what are the underlying issues that may have brought them into the courts and how to address them. And come up with recommendations about how to address those things to keep them out of the criminal justice system. So the community council program and the diversion program is another program at ALS. As I mentioned, we also have criminal lawyers available, only two. So we obviously can't represent all the Indigenous people in Toronto, but we have two lawyers who do defense work. We also have a child protection lawyer. And then we also do clinic law, what is sometimes known as poverty law, administrative law, things like housing, social assistance, those kinds of programs. We also run a child welfare, family dispute resolution, Indigenous family dispute resolution program, Gladue Court. So that assists community members who may be in conflict within their family, or may be involved with child welfare, to sit down together, again, with community volunteers and staff of our program to work through and come up with solutions that work for them and their family and community, and ideally, outside of the court process. And we also provide victim services, which I think is a bit unusual. Sometimes the worlds between sort of services for accused people and services for victims are in sort of different ends of the criminal world or the criminal justice world. But I think we see at ALS that they are often often the exact same person. Often people who come before the court as accused people have also experienced violence, either in the hands of institutions or individuals. And then those who are victims also end up being charged. So we also, we navigate, that can be tricky to navigate, but we navigate it because we think everyone needs to have their experiences either as an accused person or as a victim sort of attended to in a way that is based in services led by the Indigenous community of Toronto. And that's sort of that's how Toronto ALS sort of runs its services. We also have Gladue services. So Gladue reports are written by Gladue writers and Gladue letters and aftercare for people who are finding their way through the criminal justice system and who would benefit with sharing information about their background with the court. We have Gladue writers who that's their job to provide that to the court.
I do want to point out that it is actually important that there are services for victims as well, because even though we tend to think that it's only Indigenous people are only accused, they're actually also very often victims of very violent crimes. If I'm not mistaken, Barton, in that case, the deceased was very brutally sexually assaulted and then murdered in that case. So they are also victims of very violent offenses. So it's very good to know that you also have both sides and that you represent victims as well, because they are victimized. And honestly, to be honest, like many of them are in a situation where they are accused because they have been a victim of some atrocity in the past. So they're all victims in a way. So, so let's then talk more about who is Gladue Court meant for. I mean, I know that we kind of got into this, but let's just get into more specifics about who is this court meant for. I don't know who wants to take the lead on this one. Your Honor, it's court related. So
well, I can start, and then I'm happy to pass the baton on. I mean, look, you have to have some connection, obviously, to what it is that we're trying to achieve in this court. How that connection is established is going to vary from case to case. In some cases, I suppose it's a little more straightforward, maybe a little bit more clear how someone can demonstrate what their history is with an Indigenous community and why they're in the court. In other cases, though, it may be that the connection is a little more tenuous or perhaps not as fully explored as it could have been. That doesn't mean you can't be there. I mean, we're open, we're welcoming to people, but of course, for the principles and even the very spirit of the court to be applied properly, then there does have to be some true and meaningful connection to one's Indigenous background and culture in this country, in Canada specifically. By that, I mean, we don't assist necessarily people who might have a connection to those histories in other countries or whatnot. Maybe it would be better actually if I turn this over to Emily and Sean just to add about what their perspectives are.
I can jump in and then Shaunna can, fill in what I miss. So I will say that, Toronto's a diverse place. There's people from all over the world in Toronto. And I think that we see that in Gladue Court as well, because it really is a hub. So unlike a Gladue Court that might be sort of right next door to a First Nation community where you're really going to mostly see people from that community, we do see people from Indigenous communities right across the country. So we might have people, Inuit people, Haida people, Mi'kmaq people. And so that, anyone, First Nation, Métis, Inuit, that is who Gladue Court is aimed at. I also just wanted to note, and I think most people would know this, but it's not mandatory. There may be, Indigenous people who want their lawyer to know, yes, I'm Indigenous, I'm aware of Gladue, I don't want to attend in that court, I don't want to participate in those processes. And that, of course, is fine. That's up to clients to decide that. And so I just wanted to make sure that was clear. And I think it's obvious to people, and that it's understandable that there are people who are trying to find their way through criminal courts who misunderstand Gladue and misperceive and think that there is some benefit to claiming that they are Indigenous when they're not. And so I think it's important for lawyers, who may be watching this podcast to understand that and to have a conversation with their client about that and reassure them that they may, if they're not Indigenous, their personal circumstances that are relevant to, particular stages will be taken into account by judges or justices of the peace. And it's their lawyer's job to help them with that, but that they shouldn't be in Gladue Court if they're not actually Indigenous. ALS is certainly not the gatekeeper in terms of who's in Gladue Court. But we do have a concern that when non-Indigenous people are in Gladue Court, it is taking resources or attention away from the community that the courts were intended to address. And so that's just something that we're, continually sort of having conversations about to sort of make sure that the right information is available and people can be in the court if they want to be and should be, and aren't if it's not appropriate.
Shaunna.
Yeah, thank you. So, the principles, what we're referring to as the Gladue principles found in 718-2E, and like you said, in the bail 493.2, they start right from the beginning. So, the Gladue principles are really, they're supposed to be applied at any point where an Indigenous person's liberty is at stake. There has been multiple cases that have extended that well beyond just the criminal law into other areas of law as well. Because if you think about it, like in terms of other areas of law, people in terms of Landlord-Tenant Act or people with motor vehicles, right? The ability to drive, particularly if you live up in a northern community and there's, very little transport, or, other areas in your life where the disposition on a case, whether or not it's jail or some sort of other restriction, is going to have impacts on that person's liberty. So there's been a ton of cases that have extended that out into other areas of law. And the reason why I raise that is because one of the most important things about who Gladue Court is meant for is also intertwined with the necessity of counsel to do accurate and effective interviews for the client. Because it's not just, you don't wait until the sentencing comes up to start interviewing your client to find out, how they identify. You're Indigenous, great. What does that mean to you? What does that mean to them? How does that impact? I mean, Gladue has, 3 different steps, right? It has the judicial notice, it has the unique circumstances of the individual, and then the sentencing that's going to be fit into those unique circumstances, and that should be considered for the court for that particular person in terms of the restorative justice aspects of it. And so when we look at who is Gladue Court meant for, I think I want to just echo, the necessity to have that Emily was noting about the necessity to have counsel who are good at or maybe able to do the interviews right up front and make sure that that individual is actually in the right court. Some people don't understand, and I know Emily just touched on this already, but some people don't understand what it means to be Indigenous and if they're in the right court. And by having those interviews right up from the beginning, you're also able to help that client through the whole process and then mitigate, their position and any of the impacts on that liberty, whether or not it's criminal law or any other area of the law. So Gladue Court's for Indigenous people, but it requires some kind of upfront work to make sure that they're actually in the right courtroom, and before you can start applying the Gladue principles, which should be applied right from the very beginning. And I just want to add before we go on that topic, and I mean, it's right in through trial as well. I mean, even if the person's going to trial, I mean, things like, do they want an eagle feather? What kind of processes do they want before the trial and stuff like that? So Gladue Court may be a physical courtroom for us, but it's not necessarily always just a physical courtroom. Gladue principles can sometimes follow a person outside of that Gladue court and into the trial court. And again, it's really important for us to have that basis for why that person's in that court in the first place to be able to properly apply those principles.
Thank you. So if we now shift and we go to sentencing, because that's also a big part of what Gladue is about, how should counsel approach sentencing for an Indigenous client differently? Because it is not your usual sentencing hearing. There are other things. I mean, just the fact, like you mentioned, Shaunna, the interview with the client is different. So how do we prepare for sentencing in these particular cases?
Why don't I extend on what I was just saying, and then I'm going to pass it over because it's
Yeah.
so I think one of the I think the extension of what I was just talking about in terms of being able to effectively interview people, there's also this necessity to recognize that trust doesn't come automatically. Part of the reason that we have the disconnect between Indigenous communities and the legal system is not just because it's primarily because it's a foreign system imposed on Indigenous people. But the other reason that we have it is because there's this broken trust, right, between the parties. And so, even as an Indigenous person, I recognize that I'm also part of the legal system, the Canadian legal system. And so I don't approach clients saying, hey, just tell me everything about you. We need to be patient and take time and recognize that there is this need to be patient with the information that's shared, right? We need to open up those doors and be communicative. We need to make sure that we're not speaking in legal jargon when interviewing the clients. And so when my approach for sentencing, again, goes to echo to what I was saying before, and that is, the application of Gladue factors starts right from the beginning, right from that very first interview, because I want to ease into it. And so I think, a lot of the skills that come out of those interviews can apply to not just sentencing, but that's the best way to get an effective sentencing hearing is to take their time with the client. So I'll pass it on to someone from.
Thank you, Emily.
Yeah, I can just pick up on, I think I agree with everything that Shaunna just said. And I think it's probably obvious when we're sort of stepped away from this and having this conversation in this setting that many of these experiences that we think about as connected to Gladue factors, in terms of that person's history, their family's history, and their community's history, are really connected to really traumatic incidents. But that may be hard to remember in the it's quick, it's a quick day. You think you're having a trial, but a witness hasn't shown up and there's a deal on the table, and so things start moving more quickly than they might in your ideal situation, even as a defense lawyer who's trying to do things in a trauma-informed way. But I do think that recognition of the difficulty of the real hurt that often comes with some of the things that you're talking about for that individual and for within their family, within their community, is such an important place to start. And you can't really expect that you're going to get all that information in one meeting. And so I think, as Shaunna said, about building that trust and relationship all the way through, so that you do have that to rely on when things do change and you need to get information. And then I think having a conversation with a person who's getting ready for sentencing about why you're asking for this information. Why is it relevant? How is it going to be used by the court? What needs to be shared just with you, and what will be shared with the court, and how will it be shared? Does it need to be said in open court? Because these are open court principles. There's other people, other community members, family members may be in the room, and they may be talking about very difficult things. So having a plan for how you're going to do all that, I think, is so important. And obviously, if you have a Gladue report or a Gladue letter, you have the benefit of having some of that written down, and you're given some of that information as counsel. But if you don't have that, then it's your responsibility to be sort of gathering some of that information. And as a non-Indigenous person, if you're like me and grew up in the Canadian education system, you didn't learn about these things in school. I certainly didn't learn about these things in school. So we have to do that work on our own. And there's a lot of, now publicly available commission reports and other information that judges are directed to take judicial notice of, but that we as lawyers have to educate ourselves about, so that if we're talking about a client's, a Métis client that we're representing who was dispossessed from community or disconnected from community or pushed out, we need to know about that, or about this residential school, or about this, we need to know that history and educate ourselves so that we can help the court understand how all of this is relevant to their job, sentencing that person.
And Your Honor, from a court's perspective, if you can maybe add a little bit on this topic.
Well, what's the central consideration in sentencing, right? It's proportionality. I'm trying to look at both the objective gravity of the offense, of course, but also the moral culpability of the person who is before me. A really good defense lawyer will tell me all about their client, their background, their life story, the experiences that they've been through and their community's been through, especially in Gladue Court, and how, Canada's, quite frankly, historic mistreatment of our Indigenous peoples helps to bear on that person's moral culpability for what brought them before the court. There doesn't have to be a bright line connection per se, right? But there has to be something there that allows me to understand this in a broader context. And hopefully using that, I can come up with a more appropriate disposition in court, again, giving credence and recognition to Parliament's decision that we should take a different approach with our Indigenous peoples whenever possible, and particularly look to restorative justice processes and options whenever that can be done, and to try as hard as we can, as Emily pointed out at the start of this, to deal with this just incredible disparity about the number of Indigenous peoples who are in custody, right, which is vastly disproportionate to their place in the Canadian population more broadly. So we have to take those meaningful steps every day we get the opportunity. And the best way for me to make those decisions, right, is for you as defense counsel to tell me about your client. The Gladue reports and the Gladue letters are fantastic. They're an excellent source of information. I don't want to take away from that for a moment. But you telling me things as counsel, you've spoken to this person, you know their story, you know about their family potentially or other support networks or persons in their life that matter to them. You can help humanize that person and help me make a better decision. And really, the best lawyers that I see in that court not only know the law really well, of course, but they know everything about their client, and they can just tell me that and speak from the heart and help me to understand what led their client, to commit the offense, whatever it is, and how hopefully we can weave all of this together to come up with a better outcome, right? Looking, of course, at the authorities that exist. That type of advocacy is very powerful and very persuasive.
Thank you. But now then we get into another subject that is actually very important here. And it is, what if a client becomes disconnected from their heritage? I mean, that's a little bit of a difficult situation from a defense perspective, but let's talk about this. And I don't know if Emily, maybe you want to comment first?
Sure. I think that, that is one of the intents of a lot of these colonial policies is to break that connection, break a connection between someone and their family, their community. And so, that's the legacy of residential school, of day schools, of involvement with child welfare, of adoption, the 60s scoop. And so it's not surprising that those things happen. And so we have to, sometimes I think that's understanding that and explaining that disconnection to a judge, so that if someone is disconnected, you can explain as best as your client knows why that is, and how what they are experiencing as individual may be connected to those larger colonial and historical and ongoing factors that are important for us to explain to the court. I think I think we see this a lot at ALS, and I think it's important to meet people where they're at. My observation has been that there's a lot of often like shame and embarrassment about that for people, that it's very hard for them. They may be nervous to even be in Gladue Court. They not know how they smudge or what that even is. And so I think meeting that with some humility and some respect is really important. And offering connection to services. So ALS would be a great place to start. There's lots of other places in Toronto where people are met very graciously and very generously by members of the Indigenous community. There's also a helpful case. I will just point counsel to, it's R and Greco, 2016 ONCA 367. It's a bit old. I can't believe that case came from 2016, but it's still good law. And it talks about, in that case, the Crown's position was that someone who had been adopted out of their community and didn't know about their Indigenous heritage until later in their life didn't really have any Gladue factors. And the judge agreed with them, and the Court of Appeal said that's not right, and explained a little bit about how that disconnection is part of the Canadian Indigenous experience and how it should be factored into sentencing. And in that case, the Court of Appeal corrected the sentence and gave a significantly shorter sentence. So I think that would be a helpful case for counsel to look at if they are dealing with a client who, maybe has experienced that disconnection.
I can just jump in for a second, then I'll turn it over to Shaunna. That case is essential reading. There's another case from the British Columbia Court of Appeal I highly recommend everyone, called Kehoe. It's 2023 BCCA 2. And in that case, the offender had become disconnected from his Métis heritage. And the Crown makes this exact argument before the trial judge, right? Well, the person wasn't raised with this culture and these principles. They simply had no connection to it. Thus and therefore, the Gladue principles, as we more broadly understand them, don't apply. And the British Columbia Court of Appeal does a really great job, I think, explaining why this approach is misconceived. I mean, as Emily said, right, these policies were designed by the Canadian government in the past to do this on purpose, right, to assimilate our Indigenous peoples and to take their culture away from them. It would be quite the cruel irony if we were to say, well, I guess that worked, therefore now you can't rely on those principles today in the year 2025 in Gladue Court, right? That's not appropriate. And the British Columbia Court of Appeal decision builds off that earlier Ontario Court of Appeal decision to explain why that analysis, generally speaking, of course, there may always be exceptions, isn't appropriate. And I know I've used those authorities quite a bit. And I will say this, the vast majority of crowns that I've had in Gladue Court are excellent and embrace this whole legislative regime and the spirit and the philosophy behind it really well. Occasionally, though, you will have a case where I find this argument kind of rears its head again. And so you do want to rely, I think, on this appellate authority to make sure that you can respond to it appropriately based on the unique facts of your client in the case before the court.
Thank you, Shaunna.
Yeah, so I just wanted to kind of pick up on the themes that we've been talking about already. And the reality is that, there was an attempted cultural genocide on our communities. And this was recognized by the Right Honourable Beverly McLaughlin, is also acknowledged by Murray Sinclair and some other very prominent people in our legal realm. And the impact of that was devastating for our communities. So, a lot of our communities and our members don't have our languages anymore, right? We may not have that same connection to the storytelling. And a lot of people have lost that connection to the community. And it's not a surprise. The impact of colonialism didn't just impact, the criminal sphere. I mean, traditionally our communities share stories orally. Right. But then the colonialism comes in and everything's written down and everything, and people are given, birth certificates and renamed and taken into and assumed by, these policies from the residential schools and the Indian hospitals and other programs that, took children away from our communities and into the homes of non-Indigenous people. And then we look at the impact of that has, and then there should be no surprise that people have lost so much connection. And there is a varying degree in which people have lost those connections. Sometimes it's just the language. Sometimes they still live on the reserve. Sometimes they still have that connection, that familial connection to people, but they've lost the language. They've lost the culture. Or there's some people that have lost everything, all of those connections through either adoption or other kind of impacts as being an Indigenous person in various places. There are people that left their communities for employment because they didn't have employment opportunities, or people that left for other reasons, and education and such. And the impact of that, and Emily touched on this a little bit, the shame that's involved in going back to your community. I know that sometimes, there's a lot of pressure as an Indigenous person, particularly in my journey, as I learned more about my own culture and myself, and not that there was a disconnect, but there was definitely some spaces throughout my life where there wasn't, really that kind of that knowledge component there. And I know that moving through that, sometimes there's a bit of embarrassment, oh, I don't know that story. I don't know that language, right? Or people who speak to me, this happens quite often. because I'm so engaged in Indigenous issues, people will speak to me in Anishinaabemowin, and I have to then apologize that I don't know my own language. And it's awkward for me. I mean, I feel like maybe I should be making efforts to do that, and so there's this level of embarrassment, even though I don't think an apology is actually necessary, but it does bring up something so simple, brings up these emotions as an Indigenous person. Am I doing enough? Am I Indigenous enough? Am I participating enough? And so when we have clients who have disconnect, and then going back to that trust issue I was talking about, I mean, I sit here thinking about it all the time, right? But for people who, aren't necessarily asked all the time for their input, for that don't necessarily haven't thought it through in terms of what the impact of them being Indigenous but not yet connected or not connected in a way that they might consider meaningful, means that it's even harder to get information from that client. And so, again, going back to that whole need to have, appropriate trauma-informed interview skills of an Indigenous person regarding their background is really, really important, because it's not just how you're Indigenous, but how come there's that disconnect? Was there, what do they know about their family? Some people will respond and say, I don't know anything, right? But then the question that should be following up is why? Was there an involvement? Were you raised by your parents? If not, who were you raised by? Where is that disconnect? Where can you point to the familial breakdown? And I'll just add by saying this, the impacts of intergenerational trauma on the various different aspects of colonialism, not just residential schools, but the impacts of intergenerational trauma, you can't see them. I mean, no one walks around wearing visible scars from from the trauma that's involved in these intergenerational impacts. And so it's not something that's just so evident. It doesn't necessarily manifest itself in addiction. So you can't just say to someone, oh, they're an alcoholic, they must have intergenerational trauma. There's trust issues, there's relationship issues, or lack of, appropriate parenting that might result, or there might be subfacial issues that, someone really hasn't grasped, how it's impacting their own life. And so it's really difficult. And that's why we need culturally trained, I don't really like that term, but we need people that are trained in order to, understand and have those open communications with people, because I want to be able to tell Justice Jones, all about my client and how that's related to, the Gladue factors under 718(2)(e) or 493.2. And I can't do that if I'm just asking my client, how do you identify, oh, you don't know anything about your background. Well, I'm not going to make submissions on it. That's just not enough if we're going to effectively act as litigants in the Gladue Court.
I just add one thing
Yes.
to that very helpful explanation from Shaunna. Shaunna mentioned something that I think often escapes some lawyers in Gladue Court, just as a point of evidence law, which is that how do you demonstrate, your client's maybe connection or history with an Indigenous community? Evidence comes from many different sources, but the Supreme Court has long recognized the importance of oral histories for our Indigenous peoples and how they pass down their legends and their culture and their histories. And it's cited actually in a non-criminal case, maybe criminal lawyers have forgotten about it, called Delgamuukw in British Columbia back in the 1990s. And I've relied on that case a few times just to say, look, the Supreme Court has acknowledged this. This is a vital part of how our Indigenous peoples share their history. And that can be a form of, quote, evidence in and of itself in any hearing under the criminal code. If that's the best source of evidence, it'll be a question of what weight is attached to it. But as defense counsel, don't be afraid to explore something that you might not otherwise consider. How shall we say in a non-Gladue proceeding?
Thank you. I am mindful of the time. I know there were so many other questions that we wanted to cover as well, but there's one question that maybe will be the last one that we will cover, because it is important for practicing lawyers, and that is negotiations with the Crown. The one thing that I wanted to ask you all is, are the Crowns living up to the values of Gladue Court?
Can I start?
Yes.
So I'll try to be as quick as possible. So I think a lot of people try to get Gladue right. And I think that a lot of people on both sides, and I mean, yes, this is mostly geared towards crowns, and there are fantastic crowns that I work with, honestly. There are, I guess, my answer is going to be for crowns, but I just want to say that on both sides, I think there's also defense counsel that kind of get it wrong. And this goes back to that comment I was making earlier about the evolution of Gladue. We used to, right? We used to have like a theft under, and we'd be like, great, like let's keep this person out of jail. Let's do a guilty plea for a $1 fine because they've got a super long record, and this is just a quick way to get them out and, out of the system, no probation, right? And then those types of guilty pleas, the fast and quick guilty pleas to get them out of the system with, no probation, great, but they added up. And now these people who we've done that to can't get bail, right? And so, the problem is that we need to look long term. And the problem that I'm facing with a lot of defense counsel that come to me for advice and in my negotiations with crowns are just crowns or defense that don't necessarily understand that long-term view. What is the impact of a probation order? And why are we placing so much emphasis on the need to have a colonial probation, like a colonial system in the form of probation imposed on this individual? Why are we not empowering the community to then provide that restorative justice or that rehabilitation approach? Like, why I often ask, the Crown to justify to me while we're negotiating why they think the reporting probation is necessary. And that's really where we're failing. We're trying to do good. We're trying to keep Indigenous people out of jails. And I love that. But it's not just about the amount of jail. It's about keeping them in the system. It's about the recriminalization of Indigenous people. It's about all of those terms and conditions that we want to impose on them, which I'm not saying that there are people who need those probation terms, who need the reporting. I'm not saying it's not fit in every single case, but I'm just saying, are we looking at everything else first? And I think that's the important thing, is that I think there's a lot of really, really good intentions. I think that there is a lot of education that needs to continue in the same way that we've evolved in Gladue Court. I didn't get it right from the beginning. I still don't think I get it right every single day. And my commitment to myself and my community is to improve as a lawyer, to keep my open mind, and to continue with my own education, let alone the education that I share with others. And that's really what we need. We need a commitment from both Crowns and Defense Counsel, to continue growing in that way. Thank you.
Thank you. Who would like to add next?
I don't think I can add anything. I think Shaunna said that perfectly.
Okay, that leaves me.
Yes.
So I will just say this. In my current role, I really do find that the Crowns, at least in Toronto, who are in Gladue Court regularly, are fabulous. They really do live and breathe those principles and try to make the right kinds of decisions based on them. I can tell you in my former capacity, when I was an assistant Crown attorney, right? Obviously, Parliament writes the code and the Supreme Court has given us these decisions. But the Crown Policy Manual, at least for provincial crowns, has an entire section devoted to Indigenous justice and Gladue principles and how crowns should be factoring those into their decisions. So it's right there. The Attorney General of Ontario, which has remained constant over the last 20 plus years, has continued to instruct crowns to follow that as well. So my sort of 1,000-foot high perspective on this to young crowns would be to say, look, these principles matter. How you apply your discretion can make a great difference, and think creatively. And don't be afraid to try something there that you might not otherwise have considered in a different court, because Gladue Court is unique and it is different. And you've got everyone telling you to do so, right? From the Prime Minister and Parliament to the Supreme Court to the Attorney General of this province, right? We're all on the same page and we're all trying to make a difference properly.
Thank you. I just wanted to add on a point that Shaunna made and elaborate a bit on from a defense perspective, that even if it is a simple case, like you mentioned, a theft under, it is still important to do that work of getting to know the client and to present their story. So not to say, oh, it's a simple case, like you mentioned, Shaunna, let's just plead them guilty and be done, because every case can also it's going to be a precedent, it's going to be an entry in a record, and it will only make things worse for the client. So it is very important for each and every case to present all the history of the client and to work as much as possible, even if the allegations in this case are not very serious, but maybe this is only the beginning of other charges, and that can only make things worse for the client. I really want to thank you very much, all of you. I know I took a bit more time for this interview, but it is very important because Gladue principles are very important, and not a lot of people have a full understanding of how they appear in court and how to really address them properly. So I think this was a very important and useful panel for practicing criminal lawyers, crowns and defense. And I really want to thank you for your time. And if you have any final thoughts or advice that you want to give to practicing lawyers who have these types of cases where they need to be mindful of these principles, I give you a few moments just for final words and thoughts. Shaunna.
I just wanted to say thank you to all of the allies out there who are working alongside our community members, and thank you to everyone here on this call. It really means a lot that there's the highlight and the focus on this topic. So thank you to everybody.
And I'll just jump in to say sort of a case to watch. There's a case out of Nova Scotia Court of Appeal, RN Cope. The Court of Appeal decision is 2024 NSCA 59. Been granted leave at the Supreme Court, and the leave decision just came out on Friday, and a whole bunch of criminal defense organizations, civil liberties organizations, and Indigenous organizations were granted leave to intervene. So about sort of sentencing circles, about Indigenous people before the courts, about experiences of Indigenous people as victims and overrepresentation as victims as well. I think it'll be an important case to watch. And so I would just point that out to people. And yeah, thank you for the opportunity to have this conversation. I learned a lot listening to the other panelists.
Thank you, Emily. Your Honor.
No, I would just say, look, if you haven't practiced in this area before, come into the Gladue Court in Toronto. If you're in the city, come watch, come see what it's like. Don't be afraid. We can always use better advocates and more people who are just interested in being part of the solution. And I think you'll learn a lot. I encourage student groups to come all the time. I hope it's a really transformative experience. And I would encourage anyone who wants to come by, when I'm presiding or any of my peers are, just come and try it out for a bit and see what you think about it. And you may find you really love it.
Thank you very much, all of you, for your time. And this was a wonderful conversation. Hopefully we can talk more about Gladue in the future. So thank you very much.